The two most common mistakes that I see injured workers make after a case has been resolved with stipulations, at least mistakes in my opinion. Number one, not setting a diary, making a note in the future to file a potential petition to reopen. And number two, not continuing to treat with the workers' compensation doctors. So first, I have talked to a lot of injured workers over the years who get injured at work, resolve their claim with stipulations with request for award, and then go on about their lives. But the labor code says an injured worker can file a petition to reopen their case for new and further disability within 5 years of the date of injury. So what happens, you get hurt on a date, let's say January 1st, 2020. You get treatment, time goes by, you're declared permanent and stationary. A year later, January 1st, 2021, you resolve your claim with stipulations with request for award. You have until January 1st, or ideally probably December 31st, 5 years after that. So January 1st, 2025, and you'd want to do it a day before that just to be safe, but you have 5 years from the date of injury to file that petition to reopen. So your permanent disability was determined at that 1 year mark when the judge approved stipulations. But over the next 4-year period, if your condition gets worse, if your permanent disability increases, if you end up having surgery for your industrial injury, if the pain becomes more frequent, if the pain becomes more severe, if you're taking more frequent pain medications, you have the right to file a petition to reopen. So how do you do that? First off, I would recommend reach out to your local information and assistance officer at the local WCAB office for help with that. You need to file a petition with the board. So going to your doctor and having the doctor say, I think her condition is worse, not good enough. Sending a letter to the adjuster and saying, hey, I think my condition is worse, not good enough. You have to file a petition with the board. You need to file that petition to reopen. It has to be within 5 years of the date of injury. And if your condition has worsened, you'll go back to either the PTP or a QME. You'll go back, get re-examined, and if there is an increase in level of permanent disability, you're entitled to be paid for that. It's one of the most frequent things I see. When you resolve your case with stipulations with request for award, if it hasn't been 5 years from the date of injury, it's not necessarily over. You can file that petition to reopen. The second mistake I see, injured workers, once they resolve their claim with stipulations with request for award, they stop going to the industrial doctor, the workers' comp doctor, because, the system is frustrating, the treatment always gets denied, I can't get what I need. So they just stop going to it. But the hope of the injured worker is, boy, someday I would really like to settle my case with a compromise and release. I couldn't get the adjuster to do it before, but maybe a year or two down the road, then workers' comp will want to write me a check and settle my case and close out future medical. Here's the thing. First of all, if it's within 5 years of the date of injury, you still have that petition to reopen possibility. So if you settle with a compromise and release, you're going to need to include the value of any potential right to reopen. But the thing is, if you stop treating from the adjuster's perspective, the adjuster is going to look and say, well, Mr. Jones got injured 2 years ago. We settled his case with Stips a year and a half ago. He hasn't been to the doctor since. Why in the world would I cut him a check to close out his case with future medical? He's not using it. So the mistake I see is a lot of injured workers think the workers' comp system is so frustrating, I'm not going to go to their doctors. I'm just going to wait and close out my case with a compromise and release. That is an option if you and the insurance company can come to an agreement. But if you're not using medical care from the adjuster's perspective, there's no exposure there. Why in the world would they cut you a check to close out their liability for future medical if you're not using it? If you're not using it, their exposure is virtually zero. They're not going to cut you a very big check to close that out. So from the injured worker's perspective, if you have an accepted case, one of the biggest mistakes I see is that once the case is resolved with Stips, injured workers stop going to the doctor. Much better option, if you're in pain, if you need treatment for your industrial injury, keep going to that workers' compensation doctor. Then the adjuster is going to see the exposure. The adjuster is going to see the bills keep coming in. Then the adjuster would be more inclined to settle out your case with a compromise and release down the road. Those are the two biggest mistakes I see with Stips and an injured worker who doesn't have an attorney. Make sure you diary for that petition to reopen, and make sure you keep going to the industrial workers' comp doctor if you need treatment for the injury. If you found this video helpful, hit the like button down below and make sure to subscribe so you don't miss future videos.